Emancipation of slavery in Massachusetts. Massachusetts occupies a distinctive place in the history of American emancipation. Unlike Pennsylvania, which adopted a gradual abolition law in 1780, or New York, which followed its own gradual law in 1799, Massachusetts did not end slavery through a single legislative act. Slavery became legally unenforceable through a combination of Revolutionary-era political pressure, the language of the 1780 Massachusetts Constitution, and lawsuits brought by the enslaved people, who insisted that the law's promise of liberty applied to them as well. By the time of the 1790 federal census, Massachusetts recorded no enslaved people. The end of slavery was pushed forward by black petitioners, enslaved plaintiffs, sympathetic attorneys, and judges willing to apply constitutional principles to an old colonial institution. Slavery had existed in Massachusetts from the earliest period of English settlement. It was never essential to the colony's economy as it became in the plantation South, but it was legal, visible, and woven into household labor, maritime commerce, and farming. In 1638, the ship Desire returned to Boston from the Caribbean, with the first recorded enslaved Africans brought into Massachusetts, after Massachusetts colonists had sent enslaved Pequot captives out of New England for sale. This early episode revealed that slavery in Massachusetts was tied not only to local labor needs, but also to Atlantic trade networks. The most important early legal foundation was the Massachusetts Body of Liberties of 1641, the colony's first major legal code. Article 91 allowed bond slavery for lawful captives taken in war and for strangers who were sold to the colonists or sold themselves. The statute also promised such persons Christian usages, reflecting the Puritan assumption that slavery could be regulated morally rather than abolished. In practice, however, enslaved people remained vulnerable to sale, separation, punishment, and inherited bondage. The Body of Liberties is often identified as the first colonial legal code in British North America to give formal recognition to slavery. By the mid-18th century, it's estimated that Massachusetts had more than 2,700 enslaved adults, with most concentrated in Boston. Opposition to slavery appeared early, but remained limited for much of the colonial period. In 1700, Samuel Sewall published The Selling of Joseph, one of the earliest anti-slavery pamphlets in British North America. Sewall condemned slavery as contrary to Christianity and natural justice. His argument was morally forceful, but it did not produce immediate legal change. For decades afterwards, slavery remained protected by custom, law, and property claims. By the 1760s and 1770s, the coming of the American Revolution changed the debate. White colonists protested British taxation and imperial control in the language of natural rights, liberty, consent, and resistance to tyranny. Enslaved and free black people in Massachusetts recognized the contradiction. If liberty was a natural right, why did it not apply to them? If arbitrary power was dangerous when exercised by Parliament, why was it acceptable when exercised by masters over enslaved people? Black political activism became increasingly visible during the Revolutionary crisis. Between 1773 and 1777, black petitioners sent several appeals to the Massachusetts legislature. These petitions asked lawmakers to recognize the inconsistency between the colonists' struggle for liberty and the continued enslavement of black people. One of the best-known petitions submitted in 1777, associated with Prince Hall and other black activists, appealed directly to revolutionary principles. The petitioners simply did not ask for charity. They made a political and moral argument. Men who claimed liberty for themselves had no just right to deny it to others. The legislature did not enact abolition in response to these positions. Lawmakers hesitated, partly because slavery still had defenders, and partly because the revolutionary politics required unity among men who disagreed over slavery. Yet the petitions mattered. They placed slavery before the public in revolutionary language. They showed that black residents were active participants in defining its meaning. They also helped create the moral and political climate in which later court challenges could succeed. At the same time, enslaved people brought freedom suits in local courts. Before 1780, these cases often rested on specific claims: a broken promise of manumission, an illegal sale, disputed ownership, or the violation of an agreement. Some plaintiffs won, especially when they could show that an owner had promised freedom and then failed to honor that promise. These lawsuits accustomed Massachusetts juries and judges to hearing enslaved people make claims in court. They also demonstrated that slavery, although deeply rooted, could be challenged through the legal system. The turning point came with the Massachusetts Constitution of 1780. Drafted largely by John Adams and ratified by popular vote, the Constitution opened with a Declaration of Rights. Article 1 declared that all men are born free and equal, and possess natural, essential, and inalienable rights, including the right to life, liberty, and property. The wording echoed the natural rights language of the Enlightenment and the American Revolution. Adams may not have intended the clause as an immediate emancipation measure, but its language was broad and powerful. Enslaved people and their allies quickly saw its legal potential. The first major test came in western Massachusetts with the case of Brom and Bett versus John Ashley. In 1781, Elizabeth Freeman was enslaved in the household of Colonel John Ashley Sheffield. According to later accounts, she heard the new Constitution read aloud and concluded that its promises of liberty applied to her. She approached attorney Thomas Sedgwick, a prominent lawyer in Stockbridge, and asked him to bring suit. Freeman and an enslaved man named Brom sued Ashley in the Berkshire County Court of Common Pleas. Sedgwick argued that the new Constitution made slavery unenforceable in Massachusetts. The jury agreed. Freeman and Brom were awarded their freedom, damages of 30 shillings each, and court costs. Ashley initially appealed, but later abandoned the case. Elizabeth Freeman chose her new name deliberately. She went on to work for wages in the Sedgwick household, purchase land, and become known as a respected midwife and community member. Her case showed that the Constitution's words could be used by enslaved people as a practical instrument of liberation. The decisive legal blow came through the Quock Walker cases, a group of related civil and criminal actions in Worcester County between 1781 and 83. Quock Walker had been promised freedom at the age of 25 by his earlier owner, James Caldwell. After Caldwell's death, Walker came under the control of Nathaniel Jennison, who refused to recognize the promise. Walker left Jennison and sought refuge with others. Jennison recaptured and beat Walker. Walker then sued for assault and battery, arguing that he was a free man. Jennison in turn sued those who had sheltered Walker, claiming that they had interfered with his property. The case eventually reached the Massachusetts Supreme Judicial Court. In 1783, Chief Justice William Cushing instructed the jury that the state constitution's declaration that all men were born free and equal was incompatible with slavery. In the criminal case Commonwealth versus Jennison, the jury convicted Jennison of assault. The significance of the case went far beyond one beating or one man's status. Cushing's instructions made clear that the Massachusetts courts would no longer enforce slave ownership. Slavery as a matter of legal practice had become incompatible with the state's constitution. The Massachusetts legislature never passed a separate abolition statute to complete the process. Instead, after the Freeman and Walker cases, slaveholders understood that the claims of ownership could not survive in court. Some owners manumitted enslaved people. Others simply stopped trying to recover people who left. Transitional labor arrangements, especially involving minors or bonded servants, did not vanish overnight. By the 1790s, chattel slavery as a legally enforceable institution was dead in Massachusetts. The Massachusetts path to emancipation is important because it complicates the usual story of Northern abolition. It was not a simple tale of enlightened lawmakers abolishing slavery from above. Petitioners used the language of liberty in the Revolution to expose contradictions. Enslaved plaintiffs entered courtrooms and demanded that constitutional principles be applied to their own lives. Attorneys such as Thomas Sedgwick helped translate those claims into legal arguments. Judges such as William Cushing accepted the logic that a constitution declaring men free and equal could not coexist with perpetual hereditary slavery. For students, the central lesson is that emancipation in Massachusetts came through a legal and constitutional struggle rooted in the Revolutionary era. The same language Americans used to justify independence from Britain became a weapon against slavery within Massachusetts itself.